Let's face it, I do not believe it's the previous 7 lawyers, and I really don't believe it's Ms. Cashman. It is the client.
Accused murderer Sarah Boone is at it again, just months before her highly anticipated murder case is set to be tried. Her defense attorney motions to withdraw from the case.
Well, it's her. Obviously it's her and not the attorneys.
For those keeping score, that's the 8th attorney to want off the case.
When I see 2, 3, or 4, difficult. When I see 8, it's almost playing the system. She's just acting in an obnoxious, a system obnoxious kind of way.
Plus, there are the many letters Boone has written to the judge since her arrest.
I think it's not only unusual, it's extraordinarily dangerous.
We sit down with expert defense attorney Marco Mara to discuss the case so far and what he expects moving forward.
I think this judge is going to say, you have 2 choices, pick one. Ms. Cashman is your lawyer and will stay your lawyer through trial, or Ms. Cashman would be your advisor and you're trying the case yourself. I think this judge is not kidding. He's not going to be delaying this case very much more. I would plan on popcorn in October because it's going to be a trial to watch.
The case of Sarah Boone has captivated the nation for more than 4 years now, with multiple trial dates set and postponed, attorneys hired and withdrawn, and a handful of strongly worded letters penned by the defendant herself. But before all this, there was a murder allegedly carried out at the hands of Sarah Boone herself.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
F you.
This now famous video was recorded by Boone in February 2020. It shows Boone recording and laughing at her boyfriend, 42-year-old Jorge Torres, who's been locked inside a suitcase. Later, investigators would be called to their Winter Park, Florida home, where Torres was found dead inside the luggage.
F you.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Boone told investigators she and Torres had been drinking and playing a game of hide and seek. Boone says she forgot about Torres inside that suitcase and then went to sleep. She says she awoke hours later when her phone rang, and that's when she says she found Torres unresponsive.
My plan was not to go upstairs and go to sleep.
Well, that's what you did.
Yeah.
But not intentional of.
No, you told me you went upstairs because you were
Stop
getting
here.
ready for bed.
Stopped here.
Okay, but
Where's here?
Initially, Boone called her ex-husband, and he was the one who told her to call 911. Investigators arrived on the scene to find Torres dead with a cut on his lip and bruising around his eye. They later determined Torres had been inside the suitcase for hours and likely tried to escape.
But why is he saying I can't breathe, and why is he pushing on it as if he can't get out?
And it doesn't show a hole.
There's no hole. There's no fingers. I don't see his fingers. There's no hole.
I don't know what you want me to tell you. I don't know.
Boone was eventually arrested and charged with second-degree murder. Right now, she's still being held in the Orange County Jail. Law&Crime has followed the story since it broke and reported on the multiple trial dates set. They've repeatedly been delayed or rescheduled due to the seemingly revolving door of attorneys hired and then appointed to represent Boone. Just last week, Boone appeared in court with her attorney Patricia Cashman, but only a few days later, Cashman filed a motion to withdraw herself from the case. She's now on her 8th attorney, and this attorney just filed to withdraw from the case. So just from the offset, with 8 attorneys, what are you thinking hearing that number?
Well, it's her. Obviously it's her and not the attorneys. I mean, I've handled, obviously, thousands of cases. And look, there's often conflict with some clients, mainly because you might be telling them something they don't want to hear. But we don't take our cases personally, like a doctor. I mean, if doctors deal with blood, we deal with crime, but we know what we're doing. But someone like Miss Boone, I think she's just, if you're not in lock-sync with her, then you're the problem. Now, you tell a doctor where to cut on your body and they tell you to shut up because they know what they're doing. So that's when I see 2, 3, or 4, difficult. When I see 8, it's almost playing the system.
Marco Mara is probably best known for representing George Zimmerman, the man who was acquitted in the death of Trayvon Martin in 2012. He's very familiar with the Florida legal system and suggests that the problem is Boone rather than her attorneys. Are you at all surprised that she's yet again having issues?
Well, with her history of going after every lawyer she's had so far, it's almost, and I don't want to presume more, but when I look at a case like this, and we're demanded to give some ideas or insight, she's either just horribly obnoxious and doesn't want to go to trial and thinks this is a way to delay. That's not going to last long because this judge is not going to allow her to just keep moving a lawyer to lawyer. Or maybe she has some underlying mental health concerns that don't allow her to understand and to act within the appropriate process that we all are bound by.
During a hearing on June 7th, Boone's current attorney Patricia Cashman told Judge Michael Kranick that Boone had walked out of their meetings, making her difficult to represent. Cashman motioned to withdraw from the case on June 11th. The motion reads in part, quote, "A lawyer must not represent the client if there is a substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer." Cashman goes on to note irreconcilable differences. She noted irreconcilable differences. And for me, I hear that oftentimes when it's related to divorce. How would that work in terms of a client and attorney relationship?
So, and that's the precise reason why she used those terms. Look, I represented somebody who was charged with killing between 7 and 11 women up and down the I-4 corridor. It's Orange County's first sort of official, one of their first official serial killers. And he didn't speak to me for like 5 months because he thought I was part of the problem. But you can still do your job, right? I can still get the work done. We actually tried that case in front of a jury. But the irreconcilable differences are when you say, we should do this as the professional, like a doctor, you need this surgery, and they say, no, I know what I'm doing better than you. And unfortunately, at a certain point, you can't do your job because you have dual loyalties. You have an undeniable loyalty to your client, but you also have a loyalty to the law and to the system that you can't, obviously you can't lie to a judge. You can't have a lack of candor to the judge. You can't compromise your own ethics on behalf of a client. And it sounds as though, and I know Miss Cashman, she's a great lawyer, and it seems as though she was put in a position where the client will not allow her to do what she knows she needs to do, so she has to move on.
In that same motion to withdraw, Cashman said that she had ethical considerations. Differences there, what could that mean?
And those ethical considerations are, I want you to do this, and it's unethical. I want you to argue this, and we know the law doesn't support that argument, then you can't do it. Now, if the law allows you to argue for an extension of the law, right? It applies in this case, it may not yet apply in my case, but I can argue it should. That's all ethical good behavior. But if she is telling her to attack this witness about this issue, which is completely non-relevant, then yes, those are the ethical issues that arise where they tell you to do something as a lawyer that your ethical code says you cannot do.
Meanwhile, Boone straight up called her attorney snotty and alleged Cashman lied to her. Boone also wrote upwards of 50 pages worth of jailhouse letters to the judge saying Cashman isn't measuring up as a defense attorney. But that's not the first time we've reported on Boone's handwritten letters to the case's judge. Is that something we normally see, the communication between her from jail with the judge?
No, and there really shouldn't be, because she is sort of, in one sense, I don't want to say sealing her own fate, but look, one constitutional right that every criminal client has available to them is to not help the state convict you, right? You have the right to remain silent, not only because of Miranda versus Arizona, but way back when in the beginning, the Constitution says they can't make you testify against yourself. And even those words are not testimony in a courtroom, they are admissible. The state has them, and the state can sit back in some remorse argument or lack of remorse argument, or if she says something inconsistent, then they can use that as an impeachment. So no, I think it's not only unusual, it's extraordinarily dangerous.
I'm also wondering, as she heads to trial, if that ever does happen, could these letters be brought in, or the fact that she's gone through so many attorneys, would that be relevant at all in front of a jury?
The fact that she had so many lawyers, no. I don't think that that would be relevant. And there's this one filter that we have, that the evidence that comes into court, the benefit of it has to outweigh the prejudice of it, right? So if I have a Schwartz sticker on my forehead and it's covered over for trial, that was so prejudicial that it would never come into evidence. Unless they were saying I was part of a Nazi gang or whatever, then it's relevant, right? So you have to do that balancing. In a case like this, they would never be able to say she can't even get along with 7 lawyers. It does become relevant sometimes with what she said in those letters and whatnot. And if she were to argue in front of the jury, it's all my lawyer's fault, maybe, but probably still not, but maybe that would open the door for the prosecutor to go, it's not just this lawyer, she's done this 7 times before.
Omara says it appears that Boone is hoping to delay her trial, but the motivation doesn't exactly add up. Let's say that Sarah Boone's motivation in all of this, going through these many attorneys, is that she does want to delay her jury trial. Why would that be? She's just sitting in jail during all of this time anyway. What do you think is going on in her mind?
I think in her mind, again, if I was to sort of open up and say, here's my magic wand, what I think, she has to realize if she was out, then the idea of delaying a trial at least has some benefit. You stay out. The other harsh reality is if you're going to have a trial and may get convicted, you may want to go ahead and get your time started because you don't get out until you finish your sentence. So another counterbalance to delaying things. It seems to me, from my review of the media and knowing the case a little bit, she's just acting in a system obnoxious kind of way. Like, I am not going to give in. If she doesn't come out and see me 8 hours a day, every day, she's not being a good lawyer. Problem with it is that our standards, even as lawyers, for competency, we have to be competent at what we do. But no, I don't sit at the jail every day with every client. It wouldn't work. And I don't need to. Like, a doctor doesn't need to sit with you at lunch at home to see if you're eating healthy. No, he tells you to eat healthy, goes on to the next patient because she, as a doctor, knows what they're doing. Lawyers know how to be efficient, knows what's relevant and what gets in and what gets out and what needs to be focused on to benefit the client. And she doesn't seem to know nor care as to good, efficient work by a lawyer.
Omara says there could be some underlying mental health issue for Boone, meaning she could potentially be deemed incompetent to stand trial, but it's not super likely.
The analysis for incompetency to stand trial is sort of a low bar. So you have to know what a lawyer is. You have to know what a judge is. You have to know that you're being charged with a crime. You have to know that you could go to jail if you get convicted. It's a very low bar to be able to say, yes, I'm competent. Now, there are people out there who cannot sit for trial because they're incompetent. They cannot understand the process. And one other element is, are they aware enough to assist the attorney in their own defense? And that's an interesting one here. But again, you can't just refuse. You have to be cognitively unable to. And I don't think then she'll ever get to the point of legal incompetence in a case like this. She seems to know exactly what she's doing. Matter of fact, that's the problem with some of those letters to the judge, is that she makes, I'm not saying she's right in what she's saying about the lawyers, but she makes sense in saying it. And that means she's, sort of verbally competent.
For now, Boone is considered competent to stand trial, and that's expected to begin this fall. This trial is set for October, and if she was to move on to her 9th attorney, how would it even be possible for them to prepare all of this in time, their discovery, go through everything in time for October? I mean, would that even add up?
It could. I mean, if the judge called me up and said, you got to try this case in October, my questions would be, are the depositions done? Yes, they are. All the discovery out? Yes, they are. Medical records done? Autopsy done? Yes. Videos, body cams? Yes. All the discovery is done. So while that's a tight timeline, if you told me to do it in July, I would say just can't do it. I don't care how many records are out there, it takes time to go through them. But October is far enough off that a good qualified lawyer like Ms. Cashman or me can look at a case and get it ready. Again, we do this a lot. It's like a surgery. Yes, you have to be careful of the blood work and you have to be careful of the x-rays and all that, but we know the confines within which we work pretty well.
But there is a history of attorneys asking to be removed from a case and a judge denying that request. And if we're going back to that motion to withdraw the 8th time now, this Patricia Cashman who's on her way out potentially, what I got thinking about was, for instance, the Jodi Arias case. Kirk Nurmi was the attorney then, and he very publicly motioned, hey, I want to get off this case. And the judge said, nope, you got to stick around. You have to continue to represent her. So is it possible that the judge in this case says, I'm sorry, you've got to continue to represent Sarah Boone?
Yes. And quite honestly, I know the judge, I know Trish. This may be the one because Trish is a very good lawyer. And this judge may say, we are done here. You're not getting off, buck it up, both of you, client and lawyer. We're trying this case in November, October, whenever it's set. We are trying this case in front of 6 people. You go decide. And if you don't want to use your lawyer, that's your choice. But Ms. Cashman is competent. She has all the discovery. She has all the knowledge. She has all the law. You don't want to interact with her. That is a voluntary choice by you. I find you competent in making these decisions, and you're going to be bound by them. So we're trying this case.
If that is the route that the judge decides, that Cashman will continue to represent Sarah Boone, and let's say what you referred to there, that Sarah Boone says, I don't want to be represented by her, etc., what would that play out like in the courtroom if she refuses to have Cashman represent her?
Well, I mean, she's allowed to not interact. The judge may go so far as to make Ms. Cashman in more of a role of an advisor as opposed to true counsel, meaning she'll sit through the trial. I guess Ms. Boone can cross her own witnesses and cross the state's witnesses, direct her own witnesses. The judge can do an analysis of Boone and her competency to represent herself. And if the judge finds her competent to represent herself, not like a good lawyer, just bottom line competence to ask questions, then I can see the judge going, Cashman's going to sit in the courtroom, ask her whatever you want to ask her. She'll make sure that you follow the law and the evidence code and advise you on that. But if you really want to do this on your own, I'm going to let you. So you get Ms. Cashman as your lawyer, or you get Ms. Cashman as your advisor. But this case is going forward to trial, your choice.
What do you think is going to happen and play out in the courtroom?
I think the judge may do that second alternative and say, look, you don't want Ms. Cashman in? I'm still going to bring her in as an advisor. I have the right to do that. You can represent yourself. We'll do that analysis. I'll find you competent to represent yourself. And then when you want to use her, when you want to ask her questions, she'll sit right next to you. You can do your own opening. You can do your own closing, cross, whatever you want. She's here to help. And the reason why a judge would do that is to insulate the trial from appellate review. Because obviously, if she gets convicted, it's going to go up on appeal. The appellate court has to determine whether or not her waiver of counsel was voluntary and knowing. So I think this judge is going to protect his conviction or protect the trial, whatever the result is. Obviously, if she gets acquitted, who cares? We're done. She's not going to complain too much about an acquittal. But if she gets convicted, then the judge has got to make sure that he insulates his trial from appellate review.
Even if Boone is found guilty, there's always the possibility of an appeal. It seems to me like if she was convicted, she may want to appeal and say ineffective use of counsel. Do you think that might be the route that she would potentially take?
And which is why I think the judge will say, look, I find you want to represent yourself. I find you competent. If Miss Boone is really thinking it through, she might say, no, I don't want to represent myself. I just want a lawyer who will listen to me. But I think we're at the end. I think this judge is going to say, you have two choices, pick one. Ms. Cashman is your lawyer and will stay your lawyer through trial, or Ms. Cashman would be your advisor and you're trying the case yourself. I don't think I don't see us going to yet another lawyer, although maybe one more, but why? It's not going to change with the next one. It's going to be the same exact complaints. It's not the lawyers. Let's face it. I do not believe it's the previous 7 lawyers, and I really don't believe it's Ms. Cashman. It is the client.
When the case does go to trial, O'Mara says the jury may pick up on Boone's strong personality.
Her behavior, if it comes across in front of the jury the way it has come across for the past couple of years or so that she's been doing this with the lawyers, if she has that type of an attitude or arrogance or insensitivity or whatever, if that comes across to the jury, she will lose all favor with them. They're regular 6 people. They can look at a case like the rest of us do and say, just tell me the facts. I'm a smart guy. I know what to do. And that will work harshly against her if she doesn't change her perspective. Now, she's never been in front of a jury. I'm presuming she's smart enough to present the way she knows she should for the 6 people who are going to decide her life. But on the other hand, if she comes across as poorly as she has so far, it's going to work against her.
As an educated guess, O'Mara says Judge Cranick will deny defense attorney Cashman's motion, and she'll be required to represent Sarah Boone. Putting aside all this, the motion to remove herself from the case, or withdrawal rather, and if we're just focusing in on the details of the case, what do you think a good defense could look like for Sarah Boone, who's accused of killing her boyfriend? He ended up in a suitcase. What do you think that would look like?
Intoxication and no lack of intent. You know, some of what she said, which wasn't good about, well, this is what it feels like and blah, blah, blah. That evidence of some intent is not good for her. But generally speaking, they were drinking, goofing around. Somehow he allowed himself to be put in a suitcase. And the idea that it was just a level of intoxication and goofing around that went horribly wrong is going to be, I would suggest, the defense. That's if you think about it, that makes the most sense, right? You want to have something the jury can sit back and go, okay, it was stupid, but it wasn't criminal. It wasn't, I want to kill this guy. And that's what the defense has to present, is that reasonable doubt that she had this criminal intent to kill.
In the end, O'Mara predicts Boone's trial will begin on October 7th as planned.
I think this judge is not kidding. He's not going to be delaying this case very much more. I would plan on popcorn in October because it's going to be a trial to watch.
So far, there's no hearing date set to discuss the defense's motion to withdraw. In the meantime, Judge Michael Cranick has noted he will review Boone's 58-page letter about her attorney. Reporting for Law&Crime, I'm Gillespie.